believe I see Chief Judge on our video screen there. I'm going to ask those of you in back, because you cannot see him, we have some chairs up here, if you'd like to see, so that you can see his testimony, feel free to come on up and sit up here with us, and let's get started. So I don't know if, can you hear us, Judge?
Yes, can you hear me?
Yes, I can. We might need the volume a little bit louder. Is there any way to do that?
How's that?
Much better. Okay, whenever you're ready.
All right. I am the Chief Judge in the Southern District of California. If you have difficulty understanding or hearing me, just ask me to repeat. I'm blessed with this rare condition that makes speech a little bit more difficult. So the key thing I wanted to talk about was our selection process, because it's different than others, and I urge the committee not to make one rule for a selection, that the culture in each district may be different or will be different, and what works some places may not be effective others. Ours has existed with recent modification since the creation of the district in 1966. The judges select the panel and make the appointments, and we do this, and I'll describe the process in a moment for two reasons. One, we have always felt that there is a clear potential for a conflict if the federal public defender or community defender is making the appointment. In multiple defendant cases, there is the issue of cooperation. Certain lawyers are known as ones that will work a deal early on for their client, and that may be counterproductive to the client represented by the federal public defender. And in our district, although not at the present time, because I think the executive director of federal defenders is on your committee, and he is of the utmost ethical character. But in previous years, there were statements made like lawyers who plead their clients early for fast-track deals or to cooperate were called dump trucks. And we're concerned that they may be frowned upon in selection if the defense bar was doing it on their own. The other reason is the judges are particularly aware of the skill, the writing, and the efforts put out by the lawyers, and it's best that we evaluate them and also go through their badges. We're cognizant of the need for defense community input. And so our program works as follows. We try to solicit a diverse group of candidates for the CJA panel. Federal Defenders does an outstanding job in educating the panel and getting the word out with email blasts, etc. We can reach a lot of attorneys and get them interested in participating. Each applicant is screened by a CJA advisory committee chaired by a representative chosen by the court, and they go through the applications and recommend them, usually recommend, highly recommend, not recommend, and they explain why. With the input from the advisory committee, we have a CJA committee of the court, which is chaired by a judge other than the chief. It has district and magistrate judges. We're blessed to have a magistrate judge on the committee that was a prominent defense attorney and CJA panel member, and they screen the applications, the recommendations, and then they make the recommendations to the full court. And usually around the first meeting in December, and our court is unique. We meet every Monday at 1 o'clock and discuss court business, and so usually the first Monday in December is devoted, or late November is devoted to selecting the panel. I'm sorry, it's actually early November because the panel starts December 1st. And all 17 judges, active and senior, have a say in a vote, and a panel is selected. And the judges talk about the performance of the attorneys, and the idea is to get the best advocates for the people who are represented by the CJA panel. And the input from the lawyers at large, the committee of the court, and then all the judges, that results in a selection of the panel. So we believe that what we have been doing all these years is a good system. About a year or so ago, we added the CJA Advisory Committee, and they not only help us in the selection, but also in recruitment and further dealing with the issues that the CJA panel has. There are multiple court issues that involve the U.S. Attorney, the court, the panel attorneys, and the community defender, and we all work together in trying to reach a resolution. Plus, there's a method if a judge is behind on vouchers, etc. The CJA panel rep can call the chief, and the chief does something to help move the vouchers along. We believe it's an effective system. May not be good for any other district, but it works well in ours. We would hope the committee not have a one system that fits all of the districts. That's the main subject I wanted to talk about. I'll also talk about the exciting and titillating topic of case budgeting. But first, if you had questions about our panel selection and administration, I'd be glad to answer them.
Well, I do, Chief, and again, I'll start the questioning, but anyone on the committee may have questions. My question goes to what you were saying about the CJA committee, advisory committee, and then the CJA committee that you have set up in your district and how well it works. One of the things we've seen as we've traveled around the country, and how you think it works well, and therefore we shouldn't mess with that, I guess is the way to put it. One of the things we've seen is that as judicial personnel change, some of that can change. In other words, if you as a chief judge care about the way the CJA panel works and the CJA vouchers are being moved along and making sure that everyone's doing their job, then it's going to work well. But if you get a chief who doesn't care as much, or if you get judges who aren't as committed to it, then it may not move as well. So you've been a district judge, you're now the chief judge. How do you see, do you see any problems? Let's say your successor just doesn't pay the attention, doesn't hold his fellow judges' feet to the fire when they don't process vouchers. Do you have any suggestions for the committee on how we address those sort of problems?
Well, it's a good question, and I think the uniqueness of the way our district works helps out. At these meetings on every Monday, there's a lot of peer pressure to move your cases, get your vouchers done, do your work, help out taking trials for others, and we all work very cooperatively together. And so no matter who is chief, if the other judges hear things, they would bring them up at the meeting, and our district likes to pride itself on being very efficient. And so it's the tradition for the chief judge to make some phone calls or very politely nudge colleagues, and everybody expects that and accepts that. And so if the next chief, and I assure you he would, since I know who he is, would take these items seriously, it didn't, other judges would bring them up. The CJA committee would get wind of it and make recommendations to the court, and it would function well. As I said, this may not work in other districts. attending Chief Judge meetings nationally. I know of no other districts where the court meets as a whole every week. And I think that's our tradition. When there were originally 5 district judges, and they started this under Ed Schwartz, and it's continued, and frankly is frowned upon to miss the meeting. And that's where these topics come up.
Dr. Rucker, do you have any questions?
Good morning, Judge Moskowitz, and thank you for appearing before us. It's nice to see you. A brief question about budgeting. You've been involved in budgeting for several decades now. I'd like for you, if you could, to briefly comment about the budgeting process and what you see to the beneficial aspects of it or negative aspects, and what you might change from the way we've been budgeting here in the Ninth Circuit.
Well, the Ninth Circuit has been a pioneer in this because it was our circuit that was criticized by the House of Representatives, chair of the Budget Committee, back around, I think it was 1996 or 7. And it became a big issue. There, at the time, the Ninth Circuit was handling 20% of the capital habeas cases nationally, but spending about 60% of the national budget, and Congress wanted to know why and how we were going to get these things under control. The idea of the committee Dr. Rucker and I were appointed to was to budget these cases, and that would be a tool for case management, getting the lawyers to focus on what they needed: lawyer time, investigator, experts, interpreters, and do it in phases. We originally had 5, then 4 phases for capital habeas cases, and for non-capital cases, you can do it in 2 or 3 phases: pre-trial, trial, and post-trial. The idea is to focus the attorneys on what they need to do in the case and try to get some limits. We find that rarely are the budgets exceeded, but they act as a good case management tool. Congressman Rogers, a year or so later, was aware of this, and he congratulated the court for taking efforts to bring costs in line. It has reduced the cost because they're managed, and at the end, to me, one of the best parts is you have vouchers that are not going to be slashed or reduced because they're in line with the budget. Christine Fox, who's, in my opinion, one of the national experts, I see is going to speak with you about it. She was in on the start. And it has spread to non-capital cases the policy requires all cases where the likely expense will be over 30,000 to be budgeted. The problem is this, that judges feel incapable of doing budgeting. Now, we have budgeting attorneys, and we had a pilot project, and they are greatly helpful in budgeting, but there still is a fear and trepidation by district judges that they're out of their element. And I try to tell them that it's easy. You just sit down with lawyers, or if you feel uncomfortable, have a colleague or magistrate judge do it for you. If you think there's a conflict concern, and just figure out what needs to be done. I find the lawyers are very reasonable, and they take it seriously and want to do a good job. But it's training the judges to get over that hurdle of fear that they don't know how to do it. That to me is the problem that needs to be addressed.
Brensley, any questions?
Yeah, thank you, Judge. I was just curious if you believe that there is any back-end impact, if you will, to all the efforts that you all do with your selection process. And by back-end impact, I mean what, if any, relationship do you see between the level of work that goes into panel selection and how that impacts the issue of voucher reductions or cutting, or more globally, the independence of the defense function?
Oh, that's a good question. I would like to believe, and no one has pointed it out to me, that our district has a problem with voucher cutting. Certainly, and as I can't see you clearly, but Chip was on Defender Services with me, and we would hear stories of 10, 15, 20% cuts by judges, and without reason. I think that would be unacceptable with the Ninth Circuit, certainly in our district. When there is an issue, the judge will bring the lawyers in if it's more than a nominal sum, and on the electronic voucher in the comment section, there'll be questions, and the lawyers can answer them, and the judge then does some kind of order with a reduction. Usually there are things like this with the ECF filing. Some lawyers will list 6 minutes or 1/10 of an hour to look at every filing. And while it doesn't take 6 minutes to see that there was an arraignment, you were present and your client pled not guilty, and here's the next day. And to have a series of them day in and day out adds up. And so the judges may say, you need to group them, you don't get 6 minutes for each, and take care of it with the lawyers that way. But I don't think we have an overall budget or voucher problem. If when a judge has an issue, I'll get a call and I'll figure out how to diplomatically work on it and get it resolved.
Do you attribute any of your belief that there's not a voucher cutting problem to the extensive work you do on the front end, vetting people for selection to the committee or to the panel?
Well, frankly, I think it helps. And the lawyers know who is wasting time and unnecessarily billing. And if someone doesn't get renewed, I think the lawyers may suspect reasons as to why. But I have to say, one of the things that helps out with the panel is the Community Defenders Education Program, and the ability for them to come in and talk to us if they sense there's a problem there. Our district prides itself on being user-friendly, and that only works if the judges are open to calls from lawyers about the vouchers or problems. And it's not only me. Every judge in the district prides themselves on a user-friendly approach. And Mr. Khan wrote me on an issue, and he suggested we deal with the issue as typical of our district, of getting the people who are involved together and trying to figure out a solution. It's the people that don't share that view, I think, are frowned upon. There's peer pressure to be user-friendly.
Thank you, Judge. Glad you remember me. It's good to see you again. I think I had slightly more hair back then.
I thought that was you. It was good. You did a good job on that committee. I miss it.
Thank you, Judge.
Ms. Rowe, any questions?
Thank you. Mr. Chief Judge, I wanted to ask you a question about the CJA Advisory Committee. You indicated that a year ago the CJA Advisory Committee was formed. What led to that change? Why were they formed?
Well, it was an idea that we should get the lawyers involved, that we're seeing one side of the lawyers, but we're not seeing the other side of the applicants. And lawyers, I think, as this committee has shown, are willing to express their opinion about others in the field that are applying to be on the panel. So we thought we were missing something, and I also wanted to formalize what we had. We had always had a CJA panel representative, but it wasn't specified anywhere what their term was, what their duties were. And so we formalized that and did that with the committee. It's not only to comment on the selection process, but also to have input. One of the issues, as Mr. Gunn can tell you about, is the marshal's shackling of defendants in the courtroom. And we have tried to work things out with that, but having input and having a representative is a good conduit. Not every problem can be worked out, but it's an example of how we try to work issues out. So the need to have this committee, also they have the ability to do supplemental training. We are luckily endowed with a sizable library fund, so if they can put together a program for the panel, we would support that.
You indicated that you don't believe voucher cutting is much of an issue in your district.
I'm sorry, I can't hear you.
You indicated that you don't believe voucher cutting is a problem in your district. Did you hear me that time?
There's like an echo.
Let me try differently. Can you hear me now, sir?
Yes, thank you.
All right. You indicated that you don't think voucher cutting is a problem in your district, yet we've received information that the number one concern for CJA attorneys in your district is voucher cutting. First of all, why do you think that that's their concern? And second, I guess I best put this, I know you're the chief judge. Why do you think that the court doesn't believe that's a concern?
Well, no one's mentioned anything to us. We did have a concern with voucher problems there. For example, we have a court in El Centro out in the Imperial Valley, and that's 120 miles to the east. And lawyers will go out to represent clients, and they'll represent 3 clients, and the trip in full for mileage and time will appear on 3 vouchers. Using the electronic voucher system, we found that out, and we had to educate the lawyers that that was not proper. We also found out that there were many, well, I can't say the number, but there were lawyers that were routine billing maybe 12 to 16 hours a day when you combine all their cases. And that's unusual, but the e-voucher system allows us to catch that. And so we educated the lawyers that these are problems. The 6 minutes for each ECF filing was something of concern, and perhaps they think that vouchers are a bigger issue than they are. And frankly, if that makes them more accurate, that's a good thing. I think no one on the committee would approve of paying a lawyer for one trip 3 times or 2 times. That's just not right. But no one has mentioned, and I have as large an open door as possible about a systemic voucher problem. I would like to know if it exists.
In your district, do you keep track, is there someone charged with keeping track of that information? What vouchers are cut and how much they're cut and the reasons given for why they are cut?
No, I can ask for a report from the clerk, but there's no one who routinely does that.
During your time as... Sir.
We have a question in the back, and we're running out of time.
No, go ahead.
You'll see?
I was just going to ask,
Okay.
during your time as chief, do you know if anyone ever asked for that information?
I did. I asked I'm sorry? It was probably about 2 years ago. I've been chief 4 years, and it was probably about 2 years ago to see who was cutting vouchers and why. And I found that there were several judges that had made voucher cuts, and the reasons seemed supportable.
All right, we're running tight. Any other questions? It's not going to work on that. We need to get you...
Judge, one question. You spoke about the CJA advisory. Are you hearing me, Judge, or no?
Not well.
Not well. Technological difficulties. Judge, can you
Yes.
Okay, so the question I wanted to ask, one of the things you talked about is the CJA. And of course, you know from your time on the Consumer Services Committee that there are a number of issues that the CJA committee functions not merely in an advisory capacity, but actually makes the decision about who will be on the panel and who will be rotated off and those sorts of things. Can you talk to us a little bit about why the district decided not to adopt that model, but to adopt a fully advisory role?
For 2 reasons that I mentioned. Number one, we feel that there is a potential for a conflict if lawyers present certain lawyers who always cooperate their clients. And as I said, the rule, the word for it or phrase was a dump truck. And those were the lawyers who came in early, pled their clients, and got good deals. There was some resentment among members of the bar, and we felt, especially in multi-defendant cases, that the defense bar should not be choosing who will be representing the lawyers. The second reason, and perhaps most important, is the judges feel that they are in the best position to determine who is doing a good job and who is not. And so we see the written product. We know who files routinely late, who doesn't make a good pitch at sentencing, and those people are of concern to the court. And San Diego is the biggest city in the country with a very small town atmosphere, and everybody knows everybody else, and we feel that judges, being impartial, will have the best way of deciding who should be on the panel.
If we don't have any more questions, I want to thank you, Judge Lasnik, Judge Moskowitz, very much for your testimony here today. It's been really helpful. We are really tight on time, and so if we do have any other questions, we may get back to you and follow up. But I wanted to tell you how much we appreciate you being willing to appear before us. I know, we want to be able to fully discuss these issues, and your knowledge and your experience has been very helpful. So thank you very much on behalf of the committee, Judge.
All right, I'll just close by emphasizing that what works here may not work elsewhere, and if I certainly have concerns that if judges are knocking people off the panel because of the way they advocate, that would be a serious impediment or infringement on the needed independence of the defense bar. And that's something we as judges here firmly respect.
Thank you.
All right, thank you, have fun.
Well, we are. All right, let's get ready on the next panel.